May it please the court, my name is Muhammad Hakimi bin Abdullah, counsel for airplane Azmah, and this is my co-counsel Muhammad Amir Fitri bin Salahuddin.
May it please the court, my name is Rafael Gavin, anak Michael Jalabin, counsel for the respondent Hani Shah, and this is my co-counsel Muhammad Fikri bin Jumari.
This is a case about a contract between the parties where my client, the appellant, Azmah, purchased an electric oven from the respondent, Hani Shah. Azmah has Hani for her advice as to the type of electric oven that she should buy. Azmah bought an electric oven which has been suggested by Hani. A week later, while Azmah was using the electric oven, it exploded and burned down her kitchen.
The issue in this case, whether Azmah can sue Hani Shah for say the broken oven bridge, the implied condition that the good must be of marketable quality because the oven is explodes and burn down Azmah kitchen.
Based on this issue, Azmah can sue Hani Shah because they sell the oven with no quality to Azmah because Azmah start use the oven after a week and it exploded and burned down her kitchen. This is because the oven was sold has no marketable quality.
The good sold need to fit for the particular use to which they were sold. If they are defect of the purpose, they are unmarketable. In our case, the oven that Hani Shah sold need to fit for the particular use which they were sold. If the oven are defect of the purpose, they are unmarketable.
Your Honour, please refer to section 16(1)(b) of the Contract Act 1950 states that where goods are bought by description from the seller who deals in goods of the description, there is an implied condition that goods should be of marketable quality and free from defect, which ought to have been revealed from usual examination of the goods. Relate to our case, based on section 16(1)(b) of the Contract Act 1950, oven were bought by description from Hani Shah, who deals in the description of the oven that there is an implied condition that oven should be of marketable quality and free from defect, which ought to have been revealed from usual examination of the oven. The oven broke down for the first time of usage and Azmah can sue Hani Shah for the breach of implied condition of marketable quality of the oven sold.
Your Honour, please refer to principle that we decide in the case of Davis John V. Willis. In the case, the plaintiff purchased a pair of shoes from the defendant, David John, a retail distributor of footwear not manufactured by it. On the third occasion of wearing the shoes, heel come off while the plaintiff was walking down the stairs. She fell over and suffered injured. She sued for damage. The court held that there was a breach of condition of marketable quality and fitness for purpose. Besides, on the discussion in the case of David V. Willis, the court should decide that there was a breach of condition of marketable quality because the oven that Azmah bought from Hani Shah exploded and burned down her kitchen.
To conclude my case, Azmah can sue Hani Shah because Hani Shah sell the oven with no quality to Azmah. It is because Azma bought the oven from Hani's shop, and when she baked, the oven was exploded and burned his kitchen. Based on section 16(1)(b), oven were bought by description from Hani's shop, who deals in the description of the oven that is an implied condition the oven should be of merchantable quality and free from defect, which ought to have been revealed from usual examination of the oven. The oven broke down for the first time of usage, and Azma can sue Hani's shop for the breach of implied condition of merchantable quality of the oven sold. Based on the decision in the case of David John versus William, in the court should decide that there was a breach of condition of merchantable quality because the oven that Azma bought from Hani's shop exploded after being used for baking cakes on back home. For the foregoing reason, I respectfully request that the court find in favour of the appellant and allow my client claim for damage for breach of condition merchantable quality as provided under section 16(1)(b) of the Contract Act 1930.
Your Honor, I would like to direct your attention to the real issue in this case, which Azma cannot sue Hani's shop because the contract between them already happened and the payment has been made. Azma need to try the oven before she buy from Hani's shop. The only exception was if Hani's shop actively concealed latent defect or otherwise made material misrepresentation amounting to fraud. In this case, Hani's shop did not conceal any latent defect about the oven to Azma.
Your Honor, I wish to review the points made by the plaintiff because in this case, the offer has been rejected because a counter offer was happened. We can refer to the definition of contract of sale, which means there is complete discharge when both parties have carried out exactly what they have undertaken to do. When property passes, the seller has no responsibility to the goods because he is discharged from contract. Relating to the case, there is complete discharge when Azma and Hani's shop have carried out exactly Azma already get the oven and Hani's shop get the payment. When the oven pass, Hani's shop has no responsibility to the oven because they are discharged from contract.
Your Honor, I wish to reboot the provision made by the plaintiff because the proper provision is to be referred to in section 38(1). Please refer to section 38(1) of the Contract Act 1950, which the parties to a contract must either perform or offer to perform their respective promise unless the performance is dispensed with or excused under this act or of any other law. According to section 381, Azma and Hani's shop must either perform or offer to perform their respective promise unless the performance is dispensed with or excused under this act or any other law. In this case, Azma has made the payment and get her oven from Hani's shop. The contract between them is automatically discharged by the performance.
Your Honor, the principles of a decided court case that supports my argument is the case of Parkinson v. Lee 8, which states the fact that the King's Bench Court denied the existence of an implied warranty. In this case, the buyer decided to buy from the seller 5 pockets of hawks that were supposed to be warranted by a sample that the buyer had the possibility to examine. The further goods later delivered confirmed with the sample but had been treated with water to increase their weight. The jury stated that it was impossible for the buyer to discover that the goods had become worthless. Even though the verdict was for the buyer, Lee Blank J, who directed the jury, expressly asserted that the ratio decidedly did not involve the implication any non-written warranty. Gross J expressed his opinion about the warranty, assuming fault on the part of buyer because he did not ask for a written warranty in the contract. Relating on the decision in the case of Parkinson v. Lee 8, the court should decide that no warranty asked from Azma. Azma should check and tell to try the oven suggested by Honey Shop before make the payment, and the both parties does not mention anything about the warranty.
To conclude my case, Azma cannot sue Honey Shop because the contract between them already happened and the payment has been made. Azma need to try the oven before she buy from Honey Shop. Based on section 381, Azma and Honey Shop must either perform or offer to perform their respective promise unless the performance is dispensed with or accused under this act or of any other law. Azma and Honey Shop has do their performance and there are no performance is dispensed with or accused under this act. Based on the judgment of Parkinson v. Lee 8, the court should decide that no warranty asked from Azma. Azma should check and tell to try the oven suggested by Honey Shop before make the payment, and the both parties does not mention anything about the warranty. For the foregoing reason, I respectfully request that the court find in favor of the respondent and dismiss the appeal made by the appellant.